Good afternoon, everybody. Welcome to part 2 of our sessions. I will, it being 2:15, I'll go ahead and start. Let me just start by sharing my screen first. All right, now, somebody give me a thumbs up and tell me if my screen is being shared successfully here. Does that look good? I think
Brooke,
Amanda gave me a thumbs up, so I'll take that as a good sign.
yeah, it
All
looks
right,
good,
so
Brooke.
I'm sorry, say that again, Ross.
It looks good.
Okay, and if I'm not loud enough, let me know. I will go ahead and start. We're going to go from 2:15 to 3:15, and then we'll be done. We thought maybe a little break in the middle would be a good idea. This is, again, I'm Brook Duer. Some of you may know me from 12 years. I was with the Department of Agriculture, and prior to that, I was in private practice in Lancaster County. And then I came here to the Ag Law Center towards the end of 2019 and joined Ross. I am going to talk about utility scale solar leasing. I've done this presentation, and presentation is on utility scale solar leasing number of times in the last let's say year almost. So some of the things I'll say, if you've seen it before, you've probably heard these things, but in addition to myself, we're going to have a couple other guests here also. So we will proceed. Just want to let you know that this presentation is part of some commitments that we have with the National Agricultural Law Center to do presentations and to do educational material on solar leasing. They support our activities through a grant, as of course does the Pennsylvania Department of Agriculture, to whom we are eternally grateful. Just so you get a sense, I got roped into a team of people that is primarily started out of Penn State Extension and the MCOR, which is the Marcellus Center for Outreach and Research. And we've been doing a number of solar leasing webinars because of the proliferation of solar leases being offered to landowners in Pennsylvania in the last year and a half or so. And here's a listing, and these are links. So if you get a copy of our PowerPoint, you will be able to click on these links and actually watch all of these previous webinars that were done. We've been doing these going back to last April. And here, I think on these 2 pages are about 9 or 10 of them that we've done so far. Now, we've done a few since September 23rd. Some of them have been for more select groups like PSATs, Pennsylvania Society of Township Supervisors, I think is the right acronym there, and some others. But we are available and have done them for all sorts of different audiences. And I think it's only going to continue and get broader as solar leasing continues to proliferate in Pennsylvania. Our agenda today is going to be, we're going to have a brief 10 minutes or so from Amanda Eyer from DEP. She's an energy program specialist from DEP who deals with solar. She's going to give us an overview of solar in PA with some very nice data that will tell you sort of where particularly this type of utility or grid scale solar leasing is in Pennsylvania right now. A lot of projects in the pipeline, not a lot of projects operating, but that has various reasons for it. Then I will go for about a half hour or so on solar leasing basics and talk about specifics about the leases. And then at one point in there, we will also have Doug Wolfgang, the Bureau Director of Pennsylvania Department of Agriculture's Bureau of Farmland Preservation, join us to talk about some of the issues arising out of competing governmental interests that may cause an issue with solar leasing on a particular property. So that's kind of why we have this title to the whole thing, which is how it works and when it doesn't, because there are certain things that Doug may talk about that you'll realize it doesn't work in particular instances. So without any further ado, I will go ahead and stop sharing, and I will let Amanda take over. Let me just make sure I hit the right buttons to do this. Okay, Amanda, I'll go ahead and turn it over to you.
Thanks, Brooke. Let me just get up the slideshow.
Looks like you're sharing. I can see it.
Takes a little bit, and we should be good then.
Yep.
So Brooke just introduced me, so thanks for that, Brooke. My name is Amanda Eyer. I work in the Energy Programs Office at the Pennsylvania Department of Environmental Protection. Today we're going to talk about our current state of development for grid-scale solar within our state, and also look into some trends that are going to influence the development of that resource going into the future. So I just want to start off with a little bit of background for what current electrical generation we have within our state as of 2019. We have about 7% renewables generation in our state as of 2019, but less than 1% of that actually equals out to solar. And most of that solar is located on buildings such as people's homes and businesses, and not so much this grid scale solar that we're going to get into today. But as Brooke alluded to, you can see on here that there's a lot of proposed grid scale solar projects in our state. There's about 53 to 67 counties on this map that have some type of proposed project in various stages of development going forward. And what does that mean for a local community? I'll get into that in the next slide, but you can see that if we go from this less than 1% of solar, everything is built on this slide, it would go out to about 10% generation within our state for solar resources. And one of the big issues that's going to be discussed here later is land use. So if all these projects are built, how much land would that actually take? So we did a little bit of numbers crunching, and that would equal about 60,000 acres. Just to put that into perspective terms, we have about 250,000 acres of abandoned coal mine lands within our state currently. So there's a large potential here of proposed projects and a lot of potential for developing this resource within our state. But that also means a lot of local investment also, which is always an interest to local governments and to landowners who will be looking at these leases. So local investment potential here comes from leasing agreements that a landowner would sign on to for rent, for the land being rented to make solar. It also could go into local services and local services such as job creation of construction and also consulting fees that goes into these types of projects. But really, if this investment represents less than 20% of the investment needed to make a project a reality. Like one of the questions that is going on right now is why are all these projects being developed and proposed in Pennsylvania currently? What makes Pennsylvania a big interest that now, when it wasn't so much an interest for grid scale solar in the past? So there's a couple of reasonings for that. Some of them are economic. So on this graphic here, it shows the cost of generating electricity from solar. As you can see, solar is substantially cheaper in generating megawatt hours, which is a common unit of electrical generation, compared to some of the other resources that we have in our state, such as natural gas. This graphic here is looking at plants that are going to be built going forward. That's why coal and nuclear are not included on this graphic, because there is no plants scheduled to be built in those areas. Another economic reason for why solar is going to be built in our state is our state has an alternative energy portfolio standard. That standard requires that certain electrical distribution companies, such as your PP&L, PECO, MedEd, West Penn Power, purchase a certain amount of their electrical generation every year from solar. And as of 2017, there was a law passed that the solar now has to be located within Pennsylvania. Previous to that law, solar could be purchased anywhere in the PJM grid, which stretches from North Carolina out to Illinois and the states in between. So that has been an economic incentive for entities to build solar within our state. So I mentioned the economic reasons, but there's also climate change goals and greenhouse gas emission reduction objectives also that are influencing the trend to build grid scale solar. So as you can see on this graphic here, every year our Energy Programs Office creates a greenhouse gas emission inventory. looking at all the sectors in our state for emissions. As you can see, as of 2017, the electrical production sector accounted for about 29% of our whole state greenhouse gas emissions. Solar is a zero greenhouse gas emission technology. And if we go from that less than 1% I mentioned on the first slide to the 10% on the second slide with proposed development, it can significantly reduce the amount of greenhouse gases being emitted from the electrical production sector. Our state actually has a goal to reduce our greenhouse gas emissions by 80% by 2050. That was signed by an executive order in 2019. And another factor that's playing into this is our state has a greenhouse gas emission reduction goal, but there's also private entities and businesses such as corporations and educational institutes that are also trying to reduce their greenhouse gas emissions by purchasing renewable energy such as grid scale solar to offset their carbon footprint. Those are called purchase power agreements, and they're quite common, and they're going to be more common going into the future. So I mentioned on a couple previous slides about a 10% build out of solar, grid scale solar going into the future. So our energy programs office several years ago took a planning and modeling assessment project called Finding Pennsylvania's Solar Future that modeled out different strategies and actions to get to this 10% solar goal by 2030. And this looked at both the distributed scale solar, which is on people's homes and businesses, as well as looking at the grid scale solar. And just in general, some of the actions involve financial incentives such as carbon pricing for greenhouse gas emissions, also looking at increasing that alternative energy portfolio standard I just mentioned, also looking at different types of tax assessments on these types of projects, looking at long-term contracting, as well as looking at a main component of these grid scale solar projects, looking at uniform land siting and policies to help with the land use as well. And we had a wide variety of stakeholders that had weighed in on this, from developers and local governments to nonprofits and concerned citizens. And if you want to find more information about this plan, please go to the website that I have listed there on the bottom of this slide. So as you can see, there's a wide variety of reasons and trends for why this is occurring in our state with this grid scale solar development going into the future. We got climate action goals and greenhouse gas emission reductions. We also have some economic trends going on, besides the land availability within our state, which some of the other states in our northeastern region have kind of limited land in that regards, especially in the New England states a little bit. So I just want to leave with my contact information there if anyone has any further questions. We also have a website if anyone's looking for more information on how solar PV works in general, and also on some funding opportunities and some other information as well. So now I am going to turn it back over to Brook.
Amanda,
yes.
Before you stop sharing, one thing, can you go back to the slide where it talked about the number of projects in the PJM pipeline, so to speak, by county? And I just wanted everybody to understand the that this where was this data came from? Where did this come from, and what does it mean? In other words, this is more than just somebody signed a lease. This is actually projects that have been submitted to the PJM, and I don't know exactly the correct.
It's
grid.
Q.
Oh, PJQ.
PJMQ.
Okay, PJMQ. These are projects, correct me if I'm wrong, that have been submitted to essentially be approved. In other words, there's more than just a lease signed. They're committed to building the project, and they're trying to get the governmental approval from the Federal Energy Regulatory Commission. Is that correct?
That would be correct. For the most part, what this graphic this map is showing is these are projects that already have a lease option or agreement signed in some way, shape, or form. And then these are in the different stages of being developed through the PGMQ. So there's obviously engineering procurement stage that would look at that would look at how the grid can handle these and these arrays and these generation sites, and also construction and looking at offtake. So it's definitely after the leasing component is at least investigated and potentially signed. Is not a, I wouldn't say it's much further than that, I would say, but it's definitely at least a step or two into the process.
Okay, just okay, good, because we'll talk a little bit about that. Okay, great, thanks, Amanda. I'll go ahead and try to share now again, and I understand I may have had a little problem with not being in presenter mode before, so now I'm going to make sure that I am. All right, so if anybody gives me a thumbs up that I am in the proper mode here. Am I in the proper mode? Anybody? So that
No, Brooke, you're not quite there yet. At the top
Really?
of, yeah, we're seeing your entire slideshow. So you need to go to slideshow and then from beginning. So that's what we're seeing
Oh, wait.
your.
Yeah, you're right, but it's advancing, correct?
No, it's not.
It's not. And never had that problem before.
Yeah, Brooke, I would try going to the menu at the top. For some reason, your button at the bottom isn't working.
Really? In here in the file?
Yes, if you go, nope, go back.
Yep.
To the right of file, there's transitions, animations, and then slideshow. If you click on slideshow.
Okay.
Yep. And then from beginning.
Okay.
Far left. Oh, and that's not working. I think maybe
I think I
when
got it. Hang on a second.
when you shared your screen, you may have
Shared the
shared
wrong
PowerPoint.
screen.
Yes, yeah, exactly.
There you go. Okay. There we go.
Perfect.
Okay, so that should do it, right? Now I can advance. Why am I not advancing?
You just need to click your cursor on the slide, and it should move forward.
There we go. Scale solar leasing or grid scale solar leasing. And again, this is what some people would call a solar farm. This is the array of solar panels that you see in a field or some other undeveloped piece of property. No, we're not talking about rooftop or for personal use or even what is now called community solar. This is a situation where you're talking, and this is what these are the leases that are flying all over the place, in Pennsylvania, particularly northern tier counties and central counties, but everywhere really. And one of the things that's amazing is, everybody says, well, we don't get that much sun in Pennsylvania. Why here? Well, apparently the technology is such in today's world that, having gobs and gobs of sunshine, as the layperson would think of it, is not necessary. We get plenty of sunshine to generate just fine the needs to produce and sell electricity to the grid. This is an industry. I usually tell this story by saying there's 4 basic introductory principles here that are important to understand, and it'll start to allow you to understand what's really going on with leasing, and it starts to form the picture in your head. And I give this presentation mostly for landowners, but it's equally applicable to anyone trying to grasp what's going on. Number 1, this is an industry that's in its infancy. None of this has really been done yet to its completion. For example, there's a lot of concern sometimes. People talk about, well, what about at the end of the project, and and sort of restoring the property back to its original condition, which is generally the intent and is contained in all the leases. That's never been done yet. So we haven't been through that phase yet. We also haven't been through the phase where the agreements that are being used have been battle tested and the kinks have been worked out. We haven't even been through that yet. So that it's important to understand that this is an industry in its infancy, and there's going to be a lot of learning curve, and there's going to be a lot of, there's going to be a lot of changes in the between now and we're in the next 5 years, the next 10 years. We could do this presentation in 5 years, and we could be talking about some completely different issues. Now, this is basically a commercial lease, but it's on steroids because it's got a lot of unusual aspects and it's got a gigantic length. But this is much like a commercial lease. So it's not like leasing your fields out to, somebody to grow, row crops in. This is a lot more complicated than that, and it needs a lot more attention than that, particularly on the front end. Also, this tenant that you're bringing in is not a farmer. This tenant that you're bringing in is somebody who is extremely sophisticated and in a very technologically and financially complex business. So there's some parts about that you have to understand in order to understand the big picture. You're basically doing what in the old days used to be called a ground lease, where you're leasing your ground for someone to build something on it. That's not a standard transaction these days. Generally, you don't build on somebody else's land. You buy the land, you build something on it, and then you own the land and the buildings, or the land and the structures. It's not what we're doing here. The landowner is one thing, and then somebody else builds on your land what is essentially permanent structures. There's certainly decades, they're going to get decades of use anyway. So it's kind of unique. And this is a long-term business relationship. So it's going to run with the land. So remember that, you as the owner at the front end, or the landowner at the front end, is going to be, if this property ever changes hands, this entire project carries along with it, and the land is going to be subject to this until the lease is done. And so subsequent owners, if it's passed on to children, if it's sold, whatever it is, you're selling this property with this lease, subject to this lease, and with these structures on it. And it's going to impact all kinds of things, including potentially the tax assessment of the property, because you're doing something significantly different with it than leaving it untilled. Let's say if it once was ag property, or maybe it's in some kind of conservation program or whatever. Okay, now let me just go over some of these things. And I said a little bit of this before. It's an industry in its infancy. None of the documents are battle tested. Do never sign the developer's forms as is, because these forms have not really seen the test of time. And what's pretty much happened is that the forms that are being used are commercial development forms that might be used for office parks. Sometimes you'll see a mall or a industrial park that did things like this, where you have one owner for the real estate, and then a tenant comes in and leases with a long-term lease and builds on top of the ground. But it's pretty unusual. But those are the kind of agreements that they've taken, and they've tried to adapt to this situation. So these agreements are not battle tested, and they're not perfect, and they need a lot of tweaking, and they need a lot of reviewing, because all these different development companies are using different forms, and they're all a little bit different, and the bugs have not been worked out. Good thing about this being an industry in its infancy is that they're the deal breakers. In other words, the things that they will not negotiate with a landowner about are not really totally established yet. So it's not quite that everything is on the table to be negotiated, but a lot is. Let's put it that way. Now, we'll go over later some of the very standard things that appear in all of them, and it sort of defines how these things work. But that's just something to keep in mind. Also, you need an attorney. A landowner is going to need an attorney. There's just no way around it, because of the things that I've just said. And there's not a lot of attorneys that have worked with these before. That's okay. Basically what this is, and I'm speaking to a certain percentage of attorneys out there, this is like negotiating a commercial lease in an office park or a mall or something like, or an industrial park or a big office building. The concepts are almost the same, except it's interesting because you're having a somewhat unsophisticated landowner being the landlord, and the more sophisticated party is the tenant. And it's kind of backwards to what we're all used to. Okay, commercial lease on steroids. Most important thing is, and I mentioned the sophisticated tenant and potentially the less sophisticated landlord, but also they can last as long as 50 years. Some of these leases are going You'll see something that's been handed to a landowner and it's already written up as a 50-year commitment. So that's some, serious commitment from, a landowner who's not used to even being much of a landlord, if ever. And again, these are permanent structures that are being built. One of the novel concepts that's in here that is somewhat novel, that, everybody will be inexperienced with, let's put it that way, although not particularly difficult concept to understand, is the idea of a solar easement, which is if they're going to lease 50 acres of your 150 acre parcel, let's say, the other 100 that you hold on to, you can't let the trees grow up to a point where they're going to block the sun. You can't build buildings to the point where they're going to block the sun. One of the things that the tenant wants from the landowner is an unimpeded access 24/7, or at least daylight hours, to the sun without anything blocking the sun whatsoever. It's kind of an unusual concept a little bit. Now, this tenant has very unique needs that you have to understand the whole thing. Number one, and this is probably one of the most important things that kind of lights the light bulb over people's heads so they understand. The things that they're going to build on this property are going to be used as collateral to obtain financing to build the project. So in other words, they're going to go, the developer, the sophisticated tenant, is going to take this lease and go to, some type of financing entity, private equity, banks, whatever, and they're going to be essentially indicating, okay, we want to loan, X millions of dollars. We're going to pledge you collateral, which is going to be the panels that are ultimately going to be built. So they're building something on a landowner's property that will be used as collateral. That's important because that means that the financing that the developer obtains, that party is going to have an interest in making sure that nothing interferes with their collateral. So, for example, the primary mortgage on a property, let's say you got 150 acres, you have some type of a mortgage perhaps on it. If then you want to lease 50 acres of that to a solar developer, those 50 acres, the mortgage on those 50 acres needs to be subordinated to the solar lease so that the solar lease is superior to the mortgage, because the last thing that these developers can have happen is that the owner defaults on a mortgage and all of a sudden the principal mortgage holder for the landowner is trying to boot the solar developer off the property so they can sell the property at a sheriff's sale. To put it in its most stark terms, they cannot afford to let that happen because these solar all of these solar structures are being pledged as collateral. They can't have anybody coming in here and foreclosing on a mortgage, for example, or even fair to pay real estate taxes and then property goes up for tax sale. All those kind of things. This tenant is extremely at risk if anything like that were to happen. So because their collateral is now being impacted. So that creates a whole relationship here that takes a potentially unsophisticated land owner into a whole nother category of business sophistication that they need to be aware of. Not, insurmountable problems, but they're just new aspects that a landowner who's used to maybe leasing, some ground out for something isn't really experienced in these kinds of issues. Now, keep in mind that not only would the landowner sell their property, let's say, or they leave it to children, and then this lease will carry on, and the property will be subject to that solar lease in any type of transfer by the owner. Other way around is going to happen too, which is these structures and the lease on the tenant side will undoubtedly be assigned to new parties. We know this business is still in its infancy. It's working out, how this is all going to work over the coming decades. And there are going to be transactions, and a landowner is going to see new people come in and take over the operation. And that's one thing that is not on the table for negotiation, which is the ability of the tenant to assign this lease without the consent of the landowner to somebody else to operate it. Because there are entities out there who may just be interested in building these things, getting them operational, setting up the paperwork so that the structures are pledged as collateral for the loan, everything, and then they may end up turning it over, and I don't want to say flipping it, but that may end up being how this industry proceeds, is that certain bigger players come in and and sort of consolidate these operations. So you're going to see some turnover on the tenant side as the years progress through what could be a multiple decades, maybe even 50-year long lease. Okay. Same thing I just said. It's a long-term business relationship. You're going to have tenant identity changes, and you're going to have changes in ownership on the landowner side. So you got to keep that in mind. This is going to be shared property tax obligations. I don't think that we're going to see any taxing entities in Pennsylvania agree to separately tax the structures and we'll just say the structures and the land. So there's going to be one bill coming to the landowner, and the landowner every year for as long as this thing lasts, 50 years maybe, they're going to have to be working with this organization to divide up their tax bill. That's one of the things that is going to be something that needs to be worked out and become familiar not only to taxing entities in Pennsylvania, but of course landowners are going to have to understand how this is going to go forward and be prepared for it. Of course, the other obligation of the landowner is to make sure that liability insurance from the solar operator who's got the panels on their property is got proper liability insurance. So when the unusual wind event comes and some panels blow, might become detached, not to say that they will, but any casualty loss like that and the panels blow out in the middle of the road and then somebody comes down and hits them, all those kind of things the landowner needs to be protected with proper liability insurance paid for by the solar tenant. And that's got to be a year-to-year continuing obligation that the landowner's got to keep track of and make sure doesn't get lost in the shuffle. And that's going to be many years in the running if we're talking about a 50-year lease. And then this idea of decommissioning at the end, that's a whole there's an entire myriad of issues that come up with regard to the decommissioning obligations at the end. The basics are put the property back to the way it was when we first signed the lease, but how that plays itself out 40 to 50 years from now potentially is another entire story. And what's the cost of doing that today versus the cost of doing that in 40 years? So if you're going to have a bond, for example, potentially put up for that kind of thing, the amount of the bond's going to have to be on a sliding scale. It's going to have to escalate as the years go by, with inflation and construction cost increases and everything. So you got a whole set of issues you got to think about there. Okay, I'm going to do a couple more things, then I'm going to have Doug Wolfgang join us here. There's two parts to these leases, and after we do this, then Doug goes through his things. Then we'll talk about some more of the terms of the lease. But the big structure, the overall is there's two parts to them. There's an option agreement, and then there's the actual lease agreement. And sometimes, and I put a little note in here about what's called a preliminary letter of intent. Sometimes they'll do a little preliminary letter of intent where the landman, this is kind of like gas leasing in the sense that there are people out there that are just out there to sign up people to leases, and then they turn them over to the developers people. And so in that sense, in a lot of ways, they're kind of like landmen in the gas situation. Preliminary letter of intent is done sometimes that basically is sort of a one-page sheet that just says, well, here's the basic parameters of what we want to talk to you about. Maybe they'll give you a little bit of the financials to sort of, wet your whistle, so to speak, tell you a little bit about how much, rent might be during the option period and during the lease period. But the reason they want you to sign one of those is because of the confidentiality clauses. because they want, to make sure that maybe you're not running next door to your neighbor that they're also talking to, and that you're telling your neighbor exactly what they told you. So they want you to sign a confidentiality agreement on the front end. So that's why sometimes you'll see these one-pagers, these little letters of intent. They're not agreements to do anything, but they want to get the confidentiality clause in effect. We'll talk some more about that. Now, the two pieces, the option agreement and the lease agreement. Option agreement's usually a shorter, I'll say, maybe 10, 12 pages long. And that's to cover the option period, which is kind of like a due diligence period where they're deciding whether they're actually going to go forward, but they want to get your property into their system and locked in that they are the one with the exclusive right to utilize your property for a solar leasing project if they decide to go forward. And generally what they're doing is looking for multiple properties where the cost of delivering the electricity from that property to the power grid is the cheapest. And so they want to be close to the grid. So if they find a place that's close to the grid and they can get electricity to the grid, then they want to best, economics of the situation is to have multiple properties feeding into the grid at the same location, for example. So that means that they're generally, if they're looking at you, they're generally looking at several other people around you because they might want to aggregate you together and, save on the, sort of the cost of connecting to the grid. So that's what the option agreement does. And we'll talk a little more about it. Then there's the actual lease agreement. And what happens is the option agreement is this due diligence period where they decide whether they're going to go forward. If they decide they're going to go forward, then they present you with the actual lease agreement, and then it's away we go. They're going to proceed with their project, and that's why I was asking Amanda those questions about the one map, because I wasn't sure if that was picturing projects that had just had an option agreement signed or whether they were projects that actually had a lease agreement signed. And I think the answer is that we're not quite sure. I think those are they are between the two because they're going to the federal regulators to get approval for this particular project, and then they'll go ahead and get a lease signed and proceed. But the important part about this to understand is this is really, really important. When you're presented with the option agreement, or a landowner is presented with the option agreement, attached to it in the back is the lease agreement. The lease agreement's usually 2, 3 times as long. And what they're saying is, the option agreement says, we're going to do this, this, and this to investigate whether your property is appropriate for production of electricity for the grid. And we'll pay you a certain amount of money during that period of time while we're figuring that out, our due diligence period. Okay, great. But then it says, if we decide to go forward, then here's the lease agreement that we will request that you sign when we decide to go forward, not when you decide to go forward also. It's a unilateral option. They are locking the landowner in to say, yes, you can investigate my land for inclusion in your project. And if you decide, the developer, the tenant, the solar developer decides they're going to go forward, then they have the unilateral right to exercise the option and proceed. So what's that mean? It means the landowner is agreeing to all of these terms in this gigantic document that could bind them for 50 years, basically all on the front end. There's not any renegotiating of the lease. The terms always say, if we decide to go forward, we're going to present you with the attached lease and you got to turn it back to us in 5 days. It's always a very, very short amount of time to get the lease back to them signed. And there isn't any right by the landowner to say, oh, you know what? I decided not to go forward with this. Thanks for paying me for the last 3 years while you investigated whether my property was good for you, but I don't want to do it anymore. There's none of that. That's not in there. You have no contractual right, or a landowner does not have a contractual right to walk away. So when the landowner signs the option agreement, they are basically committing to this, and the only one that can walk away from it is the developer, not the landowner. So that's why all this work on the terms of these non-battle tested agreements has to be done now. It has to be gone over with a fine-tooth comb now, because that lease is essentially what's going to be presented, and there's not going to be a time to renegotiate. There's no negotiating that down the line. So it's very important to understand. All right. Again, I think I went over all this. This is a slide that explains the difference between the option agreement and lease agreement. I'm going to stop there, and I am going to turn one more thing, and then we'll have Doug join us. Okay, timeline of the lease agreement. Just gives you an idea of the overall projects, how these projects are working. There is, you sign the option agreement, which is the first, the option effective date I have here. Then there's the option phase, could last a couple of years. Some of them are as long as 5 years, while they try to put together a project that works and is economically viable. Get the FERC approval, as we talked about before. So there's this option period. Then if they decide to go forward, and again, if the developer decide to go forward, then the lease gets signed and they go into a construction phase. Might take, a certain amount of time to build. I don't even know off the top of my head myself. Is this a 9-month job? Is this a 1-year job? It's probably less than, it's less than 18 months, but it might be longer than 12. And so the bottom line is the option phase has one set of payments that are made to the landowner, usually annual payment. Then there's a construction period, which is going to usually be a monthly payment. Then there's the operational phase, which is going to be a monthly payment, and that's the electric generation phase. That's when power is being generated, and that is the highest rent amount. That is when the gravy's coming in. That is the main and the highest amount of rent that a landowner will ever receive, is during the generation of electricity. Then there's the cleanup phase at the end, which is, for one reason or another, project has come to an end, and there's a period of time when the property has to be restored. And it's always in the landowner's best interest to make sure that the monthly payments are as high as possible there, so that the cleanup and the restoration goes as fast as possible, so that the developer can get out from under it as quickly as possible, because they've stopped generating electricity. All right, so one more thing I was going to mention about that aspect of it. Oh, keep in mind, here's another little twist. The solar operator, in the way that I have seen the lease agreements, and I got a collection of them, the way they're written, the solar operator can unilaterally terminate anytime they want without penalties. So they don't have to buy out the end of the lease or whatever. If they want to stop, generally it's not in their economic interest to stop. They've invested on these structures. They've built this project. They're generating electricity. They're finally making money off of it. Why would they, unilaterally stop? They're going to have a number of years where the project's got to pay for itself. Then it's pure profit after that. So the idea that they would just pull up stakes and leave is not necessarily the most common thing you would anticipate. However, they have the right to do that. So the landowner does not have a guaranteed stream of income from this leasing arrangement. So just be aware, it's got some issues in that regard that are slightly unique also. Okay, now, when will this work for you? What properties won't it work for? Well, that depends on what other kind of competing legal interests are out there. We talked about a principal mortgage on the property as being a competing legal interest. And that's the idea that, well, yeah, somebody else has got to, right now, the first mortgage. Well, this lease has got to end up taking superior position to the principal mortgage, because they can't afford to have the mortgage foreclosed on and boot them out. So there's a very classic competing legal interest situation. Well, the other competing legal interests that we want to talk about are competing legal interests from governmental entities, particularly with regard to ag land. So we will now turn this over to Doug. Doug, is your microphone on? I just want to make sure.
It is. Can you hear me, Brooke?
Yes, I can. Hopefully everybody else can. If there's any problem with Doug's mic, let us know. I'm going to advance the slides for Doug, and Doug, unfortunately, his camera is not working. So we are going to talk. Okay, Doug prepared a very nice document back in August of 2019. He was way ahead of the curve on this, with regard to some of the issues regarding competing legal interests of government in a property. I mean, you can imagine the things we're talking about: preserved farms, clean and green, NRCS conservation programs. So Doug, I'll turn it over to you. Take it away.
Great. Thank you, Brooke and Ross. It's great to be part of your presentation today. I really appreciate the opportunity to talk about solar as it relates to farmland. Certainly, this has been a big issue for us in recent months and over the past year, I would say, with farm owners wanting to know what their rights are, what their abilities are to enter lease agreements when they have farmland. So in particular, productive farmland is probably subject to some program that I'll talk about really quickly today. I know we're coming up on the time. And what are those implications then as it relates to signing a solar lease? So first off, we'll talk about what we call Pennsylvania's Farmland Preservation Toolbox. I'm going to actually jump to the second one first. Is the area preserved through a permanent agricultural conservation easement? You've heard of Pennsylvania's Farmland Preservation Program, where we lead the nation. We're up to 5,800 farms and 580,000 acres. We're getting close to that 600,000 acre mark, and we'll reach that later this year. Land that's been encumbered by a permanent deed restriction. At the Department of Agriculture, we partner with 58 county governments to purchase the development rights of working farms. So if you look at that map over the past 30 years, since the program has begun, we've really expanded those areas that are preserved, large contiguous blocks. So chances are some preserved farm owners have been approached by solar companies. And if they're subject to a permanent easement pursuant to Act 43, the Agricultural Area Security Law, they are not permitted to enter a solar lease if it's for commercial solar production. They can if energy is primarily used on the farm, which increasingly is another scenario where the excess energy will be net metered or sold, but they'll be using the energy to heat the greenhouses or heat animal livestock operations. So that is permitted, and excess energy can be sold through what we call rural enterprise criteria. But that again is the state farmland preservation program. Taking a step back, and there's, like I said, 600,000 acres we're approaching in that program. Taking a step back, is the farm in an agricultural security area? That's a prerequisite for preserving it through the state farmland preservation program. We partner with over 1,000 municipalities now across the state that have developed ASAs. It's a designation at the local level where a farm owner can sign up at no cost. It's in some ways akin to zoning, but different. And if they're in the ASA, there are certain protections or benefits for that farm owner. One, as I mentioned, a prerequisite to preserve their farm. Number two would be it provides protections against nuisance ordinances and lawsuits if the farmer's engaging in normal farming activity. And then third would be certain protections against eminent domain, like if PennDOT or a township or a utility were coming through, there would be a review process by a board called Ag Lands Condemnation Approval Board. In some cases, there are a lot of exemptions to that, but that would be basically the three protections of an ASA. So if they are in an ASA, can they sign a solar lease? And the answer to that is yes. If they have not gone on to preserve the farm and they're simply in a ASA at the township level, there's no ramification or problem with them signing a solar lease. It's likely not a compatible use, and the land will likely be removed from the ASA at the 7-year review from the township, but it's not like there's a penalty associated with that. It would simply be removed. But again, that would be that first step of being in the ASA before it's preserved. And then the third tool, which we talk a lot about, sort of a sister program to the ag easement purchase, is Clean and Green. And Brooke remembers how back around the turn of the decade, when we dealt with Marcellus and all the laws, land use laws sort of struggled to catch up, Clean and Green was amended then to allow for for gas development with a limited rollback penalty. But anyway, Clean and Green is a preferential assessment where land is assessed according to its use for farming or foresting, as opposed to what its market value would be. And there's about, on average, it's been dated since we found this information, but it's about a 50% reduction. And I would say that's probably still pretty accurate, if not greater, in assessed value across the state. for farm owners signed up with Clean and Green. So can they sign a lease if they're in Clean and Green? Unlike farmland preservation, it's not a permanent deed restriction. And although no, it's not a permitted use under Clean and Green, they can sign the lease and convert to that use and pay a rollback tax penalty, and then be removed from the program, and any remaining eligible acreage could be re-enrolled by that farm owner. So there, I'm sure that could be negotiated in the leases, and has been already, because there's 10 million acres of privately enrolled land in Clean and Green across the state. So again, to summarize, no, it's not a permitted use, but yes, it is something that the farm owner can do if they're willing, or the solar company is willing to pay a rollback.
Right. Hey, Doug. Hey, Doug.
Yes, sir.
I was going to just interrupt. Sorry. By the way, you have the rest of our time. I'll just turn it over. You can take it all till 3:15. And I will say, many of these developers consider this to just be the cost of doing business. If they are after your property and they like it and it fits into their plan, paying a rollback tax as part of what's necessary to get the project going is perfectly, may very well be perfectly fine with them. And all the leases, provide for that. So that's a very common thing that they seem to be very well aware of. So go ahead, Doug.
Sure. Yeah. So just, I guess, taking it a step back, as Amanda had mentioned about Pennsylvania's Solar Future Plan has a goal of increasing solar capacity to meet about 10% of the Commonwealth's overall energy needs by 2030. So I've heard a figure as high as 80,000 acres will be needed in order to reach that goal. And you think of Pennsylvania land use and you think of land that's cleared and open, and especially in South Central, Southeast, that means farmland. And so the intersection between solar and agriculture is only going to become more stark over the next decade in trying to reach those goals. And from our perspective, we understand that the goals of renewable energy and farmland preservation aren't necessarily exclusive. And it's interesting to see like some of the other states and what their policies are as it relates to this. I'll just give an example. Michigan, for example, when it's preserved farmland, recognizes solar as a compatible use, and it's something that they allow for. Meanwhile, the New England states are struggling to find that balance between, providing for renewable energy with also, protecting other natural resources through land conservation. So the American Farmland Trust, which is a nonprofit organization out of Washington, D.C., is working with New England states on a smart siting plan for finding that balance between, not only energy production, renewable energy production like solar, but also with preserving farmland and keeping it available for ag production. And I think something as a Commonwealth that we'll need to learn a lot more about in Pennsylvania is agrivoltaics. And how are the two uses compatible? Does it have to be one use or another? For that 80,000 acres, assuming many of those acreages are farmland, must it be one of those uses or another? Or are there compatible uses like, pollinators, grazing? We've heard about in irrigated places where vegetable crops benefit from the shading provided by solar panels. So what does that look like for Pennsylvania agriculture? And I think that's something, we'll probably have to be looking at a lot closer as we move forward, so it doesn't have to be one land use over the other. But anyway, getting back to this list here that I'm talking about, the fourth consideration, won't get into much of this, is zoning, and that's all done, as you know, locally under the authority of the municipality's planning code. And in many cases, it's my understanding that zoning doesn't identify commercial solar as a specific use. So in that case, then, in order to be permitted, it would have to be allowed for as another use, what's called expressly permitted. And so, definitely farmers should check, or farm owners should check with their municipalities and their county planning. Just to give an example, Cumberland County's comprehensive plan in one of their model zoning ordinances says that in ag zoning districts, no more than 50% of the entire area for development shall consist of class 1 and 2 prime farmland soils. So that's basically the most productive farmland that's out there. So that's in Cumberland County, that they have that townships, I believe, can voluntarily adopt that provision, that no more than 50% of the area that has that prime farmland shall be used for that activity. So again, zoning is done locally. What we've really seen over the years, obviously, sort of a progression of comprehensive ag zoning over the past decade, 2 decades, 3 decades, where agriculture is zoned for specifically. And so that's been, I think, a good thing. And then is solar considered to be, that's okay. Is solar considered to be agriculture by definitions of those laws I just talked about? And no, it's not. We call it solar farming, but it's not farming by those definitions, and it wouldn't be afforded the protections under the Right to Farm Act that I'm aware of as an agricultural commodity and engaging in normal farming activity. So you can flip that, Brooke.
Yeah. Okay. Right there. Well, there we go.
Oop.
Do you have it?
Yeah, so I won't get into too much of this with permitting, but it's my understanding that a permit would be required as it relates to stormwater discharge under the NPDES. And then farm owners obviously should consult with the conservation district or their DEP. Amanda may have further information on that. And then another program which is widespread, and as we look at the new administration, the Biden administration's push toward climate change goals, it wouldn't surprise me if CRP and CREP would see a renewed boost. But that's where acreage is signed up through USDA for basically set aside to be in a vegetation state for a period of 15, 30 years. I'm not sure what those current contracts are in exchange for sort of a rental payment. Touch base with Denise Coleman from the state conservationist from NRCS, just to make sure this policy hasn't changed. And to her knowledge, it has not, that solar panels are not permitted on CRP and CREP contracts. And definitely the farm owner should check with USDA as it relates to that. And then to that end, with conservation and best management practices, obviously we've invested a lot of resources, especially in the Chesapeake Bay watershed over the past years with conservation plans, and those practices that were installed, if they would be impacted or affected, or there would need to be and there was cost share involved in putting those practices in. Definitely, again, want to make sure that the farm owner would touch base with NRCS to make sure there's no issues with that. I would say at a minimum, the conservation plan will need to be updated to reflect the change in land management practice if the land underneath those panels is converted to permanent grass or permanent cover. So that's just in a nutshell, farmland considerations as we see it, but definitely a hot issue for us and something that we feel we'll be talking a lot more about in a few years ahead.
Great. Thanks, Doug. I appreciate that. Sorry, we're so pressed for time because we could sit here and talk another hour. A couple questions that we got over the Q&A and the chat function I will address here. One thing that Doug mentioned was zoning, and I have a whole bunch more slides, which we won't really have time to get into, but just be aware that the level of regulation is very unusual here, because you notice we have never mentioned the PUC in any way, shape, or form in this presentation. Why? Because the PUC has no regulatory jurisdiction. This is purely a Federal Energy Regulatory Commission, a FERC issue with regard to supplying the power to the grid, and that is handled by the developer themselves. And then PUC is not involved. And then the other approvals that would be needed in order to conduct this activity on whatever land might be at issue, the standard things that you would need if you're during the construction phase, an ENS plan, and all those kind of things with your local conservation district. But really, there's very little else except for local municipality zoning. That's the primary regulator here, at least on the front end of these things. And so at this point in time, while we have some municipalities that have provisions for recognizing grid scale solar generation as a use, most don't. So you're most of the time dealing with a conditional use application in that case, in front of the Board of Supervisors. And that's what we're seeing going on around the state right now. And there's some pushback. There's clearly some pushback. There's concern about loss of farmland, legitimate questions, as Doug referred to, something we're going to have to talk about a lot. And so that is all the responsibility of the tenant to go to the township and get all these approvals. The landowner, basically sits back and watches it happen, and keeps their fingers crossed if they want their rent. Somebody asked the question about
And Brooke,
yes.
I want to interrupt here. We want to make sure we get that second CLE.
Oh, yes. Oh, that's a very good point. I'm glad you said that. Okay, second code word for your CLE attendance form is energy. So our first one was solar, our second one was energy. Okay, now I'll make this very quick. First question we had is there variable rent based on how much electricity is produced? The answer is no. This is all a flat rate. The landowner shares in no way in revenue produced by the electricity or produced from the electricity sold. So this is purely a flat rental situation where you're going to get a flat rental rate. The size of parcels that they're interested in, that's a good one. There's other people at Extension and others with Penn State who are better qualified to answer that one than I am. Obviously, larger within reason is better. They're not going to put the money into, small 10-acre parcels. Obviously this is going to be, on a much larger scale to be economically viable. I think we'll be shocked as sort of as a population of the Commonwealth to learn how much some of these projects cost in terms of putting the panels in and making it operational. It is not cheap. We'll just put it that way. And somebody asked about rollback taxes. I think we talked about that in terms of, the leases generally have broad clauses that talk about any and all expenses incurred by the landowner as a result of this project will be the responsibility of the tenant. And that includes if they wish to go forward, when they discover that, there's going to be a rollback tax under clean and green of, X, whatever it may be, then that's their prerogative. And I think that the developers understand that fully and are willing to take that on if the economics of the project makes sense. Okay, I don't want to go further. I think we're 3 minutes over. Ross or Jackie, anything else that I should mention in closing here? I'll let you guys take care of that.
No, I would just say we look forward to seeing you again Thursday at 1 o'clock. Thank you, everyone.